afternoon, everybody, and welcome to the first in the series of Tanfield's new lockdown webinars, COVID-19, an overview for property litigators. Now, Katie and I thought that we had positioned ourselves safely down the queue of speakers, but for a number of reasons we found ourselves thrust to the fore and exposed, therefore, to the full range of gremlins and teething problems which can attend these things. So we hope that everything goes to plan, but please bear with us if it doesn't. Now, because we're the first in the series, the intention is to offer a general overview of the property litigation landscape in the light of the crisis. We do appreciate that this is a topic which has not exactly been absent from the screens that we've all been staring at for the last few weeks. And we are not kidding ourselves that everything we say is going to be new and original to everybody who's listening. But we do think that an overview is timely for two reasons. First of all, of course, the past few weeks have been a period of such tumult, with so much happening on what has sometimes felt like a daily basis, that we feel that now is a good time for a high-level overview of that. And certainly the process of preparation for this talk helped me in fitting all the pieces together. And secondly, at the risk of tempting fate, it feels as though for the first time since late March, we're just drawing breath. So now is a good time to peer anxiously out and see what is happening. Of course, the anticipated release of lockdown measures may lead to another flurry of legislation, which we'll review as and when. So if we can just move on to the next slide, we've provided here a chronology of the main events of the last 6 weeks, and the plan for the talk is to follow things in a roughly chronological order, although we'll depart from that as and when a particular theme requires us to take a development out of sequence. Katie is going to talk about the primary and secondary legislation which hailed the beginning of this extraordinary period. I'm then going to look at the tangled history of the practice directions, and we'll both then consider some of the resulting case law, including what that tells us about the current state of play in relation to remote hearings and compliance with directions regimes. Finally then, Katie will look at what the government has announced it has in store for the future. So far as questions are concerned, we've decided for various reasons not, I'm afraid, to invite live questions using the chat function. If you do have questions, please send them to the Chambers events email address, events@tanfieldchambers.co.uk, or of course directly to Katie or me if you happen to know our email addresses. So I'll now hand over to Katie to talk about those legislative changes, which it seems amazing to say came in force a mere 6 weeks ago.
Yes, thank you very much, Andrew. So if we move to the next slide, which is entitled Coronavirus Act 2020, that is the legislation which gives tenants protections during this time. It came into force on the 26th of March. And commercial property and residential property are dealt with by two separate sections. So let's look specifically at residential property first on the next slide. The headline to take away really is that in almost every case, 3 months notice will be required before possession proceedings can be issued. And those new provisions apply until at least the 30th of September 2020, but the Act does provide for an extension of up to 6 months to be made by regulation, so we're not quite sure how long this is going to be going on for. Most people generally now are dealing with assured and assured short hold tenancies, so we'll look at those first. Where possession is sought on a fault-based ground, so Section 8 and Schedule 2 of the Housing Act 1988, 3 months notice is now required to be given in the notice seeking possession, and that is the case for every ground for possession. That's a significant increase. In rent arrears cases, normally one's looking at 2 weeks notice, so it's quite a significant burden being placed on residential landlords at the moment. And I'm starting to see perhaps some unintended consequences that are arising out of this in relation to antisocial behaviour cases, because the 3 month rule also catches those grounds And because everyone is at home and locked down in their homes, they're becoming more and more aware of how their neighbours are behaving, and if their neighbours are behaving in a particularly antisocial way, complaints are being made to landlords. But the landlords can't do anything about it at the moment because they are stuck with a 3-month notice period. In very serious cases, where there's criminality, drug dealing, in one of the cases that I've got at the moment, even arson, we're having to look at trying to get the police involved with closure orders and things like that. So that is potentially another way of going in antisocial behaviour cases where you can't now rely particularly speedily on the Act, the 1988 Act. The same time period, the 3-month time period, also applies to Section 21 notices. 3 months notice is now required rather than the traditional 2 months, and that's the case even though Section 21 notices are non-fault based, and the landlord could conceivably be giving notice for grounds that are completely irrelevant and not related at all to coronavirus. The section is still caught. Similarly, as regards Rent Act tenancies, 3 months notice is required to determine a contractual tenancy if you've still got one around, although that's very unlikely. In relation to the statutory occupation that arises after determination of the contractual tenancy, a new notice is required of 3 months of intention to serve possession proceedings. That's a completely new requirement that has never existed before. Traditionally, in Rent Act cases, you just serve your possession claim and set out your grounds in that. So there are new notice requirements in relation to Rent Act cases. If we move over to the next slide, we can see that the same time limits apply to secure, flexible and demoted tenancies. The only real exception is trespasser cases, where there is no new requirement or requirement at all to serve any notice, and that applies to your traditional squatter type trespassers and also to people who have become trespassers by virtue of their lawful occupation being determined and them staying on the land. But that latter type of trespasser has some additional protections that we'll come to look at when we discuss the practice direction, the new practice direction, in a moment. What the real thing to take away from the residential property provisions is that existing notices remain valid. So notices served before the 26th of March 2020 is still valid. For notices served after that period, there's a new Form 6A and a new Form 3 that takes into account the changes, and you must use those forms because it's a prescribed requirement to do so. And you've now only got 3 months to issue your Section 21 claim following expiry of a Section 21 notice because of the 6-month use it or lose it provisions that are still contained within that section. Let's move on then to the next slide, which deals with commercial property. And really the headline to take away here is that landlords of commercial properties may not forfeit leases of commercial property for failure to pay rent or failure to pay other sums due under the lease, such as insurance, rent and service charges, until at least the 30th of June 2020. And again, this is subject to extension by regulations. Section 82 applies to all tenancies to which the 1954 Act applies, or tenancies that would be a 1954 Act tenancy if the occupier were a tenant. So that really catches most properties occupied for business purposes, even if the tenancy is a contracted out tenancy from the 1954 Act. And it also catches head leases where the occupier itself isn't in occupation for business purposes but has sublet or has granted a license to people who are occupying for business purposes. That prevents the head lease being determined by forfeiture and then the derivative interests falling in. To some extent, Section 82 is retrospective in that existing possession orders that were made before the protective period that take effect during the protective period will now not take effect until the 30th of June 2020 or at the end of any extended period. If exceptionally your possession order was made in the High Court, then an application will need to be made to extend time, but that will be granted if it is made. In the County Court, the extension of time is automatic. The problem really that I can see, and that I think most people can see with all of this, is that really you're just staying the evil day. Rent is still due. The landlord's still going to be able to forfeit for the arrears at the end of the protected period, and its ability to waive the right to forfeiture is now very much reduced, because it can only do so by an express waiver in writing, which is going to obviously be very unlikely to be given by a landlord. The landlord can still forfeit for other breaches. It can still serve a Section 146 notice in relation to breaches that don't relate to rent, although I wonder whether there might be some fruitful arguments about how long a time you need to give in your Section 146 notice to remedy the breach in the current circumstances. That's probably another matter for another talk. So it's really easy to see how a motivated landlord that wants to get rid of a tenant could still do so by forfeiture in the current climate if it wanted to, and despite these regulations. So that deals with the 2020 Act. I'm going to hand you back now to Andrew, who's going to talk about the new practice direction in relation to Part 55 claims.
So a few days after the Act, by these words issued on the 26th of March 2020, the Master of the Rolls caused consternation to landlords and mortgagees up and down the land, not to mention large swathes of the junior Chancery Bar and, I'm sure, litigation solicitors as well. The reason for this wholesale suspension of proceedings was not tenant protection, nor was it health related. The reason was really administrative, and is born out of the fact that there are, amazingly, and I didn't know this, 2 million claims issued in the County Court in 2019, 130,000 of which are possession claims. By contrast, there were 3,000 claims issued in the High Court, 150 of which were possession claims. So this was really about easing the administrative burden on the County Court. But two questions immediately began to be asked. The first was whether this practice direction was legal at all. Can move on to the next slide. The reason that doubts began to surface about the legality of the practice direction really emanate from the wording of CPR Part 51.2, which is the rule under which the practice direction is made. That provides that practice directions may modify or disapply any provision of the CPR during the operation of pilot schemes for assessing the use of new practices and procedures in connection with proceedings. My emphasis on those words. But the obvious problem here is that this was not really a modification or disapplication of certain provisions of the rules so much as a wholesale suspension of the right to litigate at all. And the second problem is that this was not a result of the operation of a pilot scheme. There was no attendant pilot scheme. And so questions began, as I say, to surface about whether or not the practice direction was lawful. This was put to the test in a case in the Central London County Court, Arkin and Marshall, by a colleague of ours, Michael Walsh. This was a mortgage possession claim in which directions had been given prior to the lockdown. His Honour Judge Parfitt took the view that the practice direction left him with no discretion but to stay the directions, including in particular a direction for the provision of disclosure. That was then the subject of an appeal, and permission was given to bring a leapfrog appeal to the Court of Appeal, which was heard on the 30th of April 2020. Judgment is awaited in that. So the second question, if we can move on to the next slide, was really about whether, legal or not, the practice direction went further than was intended or was desirable. And this question led to some high-level correspondence between the Property Litigation Association and Property Bar Association jointly, on the one hand, who wrote to the Lord Chancellor, drawing attention to the very far-reaching effect of the practice direction. And their letter, a section of the text of which I've cited there, drew attention to the fact that it was not limited to housing possession proceedings, but also stayed possession proceedings relating to trespassers against tenants of commercial premises holding over, and claims against former tenants of agricultural holdings. To move on to the next slide. On the 20th of April, the Master of the Rolls Office responded, asserting forcefully the legality of the practice direction, but saying this: "You will, I'm sure, be pleased to hear that the Master of the Rolls will, with the consent of the Lord Chancellor, make an amending practice direction which would exempt from the practice direction 51Z 1, claims for possession against trespassers, 2, interim possession orders, and 3, applications for case management directions agreed by all parties. And that amendment was duly effected on the 18th of April. That, however, has not brought matters to a close, and some uncertainty still attends the exactly which claims against trespassers are caught by the practice direction, as Katie will now explain by reference to some recent case law. If we can move on.
Thank you. Yeah, thank you, Andrew. As you'll see from what Andrew said, what the PBA and the PLA asked for was a disapplication of the practice direction in relation to claims against trespassers as defined by CPR 55.1b. What they got was a disapplication of the practice direction in relation to claims against trespassers as defined in CPR 55.6, which is the persons unknown definition. So it seems that the practice direction is disapplied in traditional squatters' claims, where a squatter has come onto someone's land and set up camp, but not in relation to a claim where someone has become a trespasser because their lawful occupation has become determined and has been determined and they have stayed on the land. So that sounds straightforward, but with every new rule there are always questions. And some of those questions relate to what happens if you know where you've got traditional squatters that have come onto your land, but what if you know their names, or what if they tell you their names, or if they seek to avoid possession proceedings by writing all of their names on the door? Does that bring them within the scope of the practice direction, and is a claim against them stayed? That may sound absurd, but there are groups of professional squatters who are well versed in the legislation in this area, and no doubt will understand what the practice direction says. And I can see this happening, and I expect that this sort of claim is going to be coming before the courts on an urgent basis, and I would imagine in the next few weeks or months, whilst the practice direction stays in force. It really remains to be seen how the court will treat any claim to be protected by a trespasser who has given his or her name, but I would hope that the court would apply the spirit of the practice direction rather than perhaps its strict wording, but we'll have to wait and see. For my part as well, as Andrew said, applications for interim possession orders are now not caught by the practice direction, but I question really whether interim possession orders are particularly useful. I don't find them particularly useful remedies at the best of times, let alone now. So they only apply to land where there are buildings on the land or the land is ancillary to a building. So open land where, for example, fly tipping might be happening, and you can imagine at the moment that probably quite a lot of fly tipping is happening on open land because local council waste sites are not open, wouldn't be caught by an IPO. Secondly, they can be quite stringent. You do have to make the application within 28 days of becoming aware of the trespass, and you do have to give undertakings to the trespassers, which may not be particularly palatable for some clients. And the real problem is that the teeth of an IPO, the reason that they are supposed to be effective is that if the trespasser doesn't leave, their occupation becomes a criminal offence and they can be removed by the police. But even in the best of times, the police are pretty unwilling to get involved in trespasser actions, even when an IPO has been made. And I can well imagine now that it's going to be pretty tricky to persuade a police force in the current climate to get involved in one of these claims. Let's move on then to the next slide, which deals with injunctive relief in trespasser cases. Claims for injunctive relief are not precluded by the practice direction, and they never have been. They were still available before the practice direction was amended. And the first decision that we've seen in this context is in the case of UCLH, NHS Foundation Trust and MB. And that was a case involving a quite odd set of circumstances, and quite ironic set of circumstances, where the hospital trust couldn't get their patient out of a bed that they needed for COVID-19 patients because of the existence of the practice direction that is supposed to be protecting everybody in these times of COVID-19. So it was a bit of an unintended consequence of the practice direction that the hospital trust was caught in this case. Nevertheless, they made an application for an injunction, and the court held that they were entitled to an injunction to remove the patient from the bed so that it could be freed up for COVID patients. And the judge said that the state of the text that is highlighted and quoted on the slide, which is a property owner is entitled to an injunction to enforce its rights against trespassers. Now, there was obvious practical sense in that decision, but I do wonder whether it will survive in a post-COVID world, because whilst injunctions and possession orders are often used together, the way that they're ordinarily used is for the possession order to be made in relation to occupied land and for an injunction to be put in place to prevent the trespassers then moving on to other land that is owned by the landowner. In this case, in MB, the injunction was used really to put the hospital back into possession, which seems to me to go quite a lot further than the authorities that we've seen before in the past. And so we'll see if that survives. The other real problem with having an injunction instead of a possession order is an issue of enforcement. A possession order can obviously be enforced by sending in High Court bailiffs to move the trespasser out if they don't leave, but in an injunction case, if the occupier won't leave, despite the injunction having been made, the remedy is really to persuade a judge that that person ought to be committed to prison for their contempt. And again, at the moment, I really do wonder if it's going to be easy to persuade a judge that someone should be put into the prison population, where social distancing is obviously going to be much more difficult to achieve. So again, we'll wait and see on that. It's also important to remember that an injunction is an equitable remedy. Obviously, the facts in UCLH were particularly exceptional because the bed was required for COVID patients. I would suggest that unless your case has got similarly exceptional facts, it's unlikely in the current world to be equitable to injunct someone to leave a property in circumstances where you wouldn't ordinarily be able to get a possession order. So that's trespassers and the effect of the new practice direction. I'm going to hand back now to Andrew to look at case management in a COVID world.
Thank you, Katie. I've had some feedback while Katie's been talking that some people are having difficulty seeing us. I think the hope was that we could be seen, but anyway, I hope that you can at least hear us loud and clear. So the next major development in the last few weeks was the introduction of Practice Direction 51ZA on the 1st of April. Like 51Z, it was a very short practice direction, and it has two main effects. First of all, it replaced a reference in CPR Part 3.8 of 28 days with a reference to 56 days. Just important to be clear what this means. CPR Part 3.8 doesn't deal with time extensions generally. It deals with time extensions in relation to orders, rules and practice directions where a sanction is provided in the event of non-compliance. So whereas previously in such cases the parties could agree an extension of 28 days, now they can agree an extension of 56. The second effect of this practice direction is that it provides that any extension beyond 56 days requires the permission of the court. Now, I think the reaction generally to this has been that it's a rather liberating practice direction, if not a charter for delay. But in this respect, actually, it makes the regime tighter because previously under CPR 211, parties were free to extend time as they wished in writing without limit, save in circumstances prescribed by the rules. The effect of this part of 51ZA is that you cannot do so, at least for more than 56 days, without the approval of the court. Another important point to note is that CPR Part 211 provides, as I've alluded to, that certain dates within the rules may not be varied by the parties. And this part of the CPR remains unaffected by 51ZA. The time limits that can't be affected include, in the case of fast-track trials, the return of pre-trial checklists and the trial or the trial period. And in the case of multi-track trials, those dates, as well as dates fixed for the CMC and the pre-trial review. Most of those are, no doubt, as one would expect, they're important staging posts in the course of litigation, and one would not expect to be able to move court dates without the assent of the court. But the provision about the return of the pre-trial checklist is in a slightly different category. And so it should be clearly understood that, on my reading at any rate, there is no ability to extend time for filing a pre-trial checklist without the permission of the court. And furthermore, of course, as many of you will know, the sanctions for failing to file a checklist can be extremely strict, and the court will make an order requiring it to be filed within 7 days. And if that is not done, the court will strike out the claim. So that is a definite pitfall that I think nobody should kid themselves has been removed by 51ZA. Finally, 51ZA requires the court to take into account the impact of the pandemic when considering applications for extensions of time under directions regimes. And I want to move now to see how that has been interpreted in a variety of different cases. There's 4 cases that probably need to be referred to. The first 2 can be looked at fairly briefly. They're unreported decisions. The Kazakhstan case you see on the slides there, and Rees Smith Technologies. The Kazakhstan case was really the first declaration of intent from the judiciary, a decision of Mr. Justice Teer on the 19th of March, as a result of which he refused an application to adjourn a forthcoming commercial court trial. Citing guidance which had been given by the Lord Chief Justice that morning, this was the first pandemic guidance, and of course predates the Coronavirus Act. Mr. Justice Teer said, "It seems to me that having regard to the need to keep the service of public resolution of disputes going, it is incumbent on the parties to seek to arrange a remote hearing if at all possible." A week after that was the decision in Rees Smith Technologies, a decision of Judge Jones in the Insolvency and Companies Court on the 26th of March. Again, the effect of that was to refuse to adjourn an imminent trial, and Judge Jones issued some rather chilling words for the more technophobic amongst us, saying it's being contended that the legal team for the respondents has no previous experience and there is insufficient time to learn to be able to participate fully and fairly. Bluntly, that is not good enough. Solicitors are going to have to act quickly. They need to practice Skype and put in place procedures to enable them to be effective trial lawyers. Nevertheless, that perhaps even then did not grab the attention of the legal profession, and it was really the decision in Re 1 Blackfriars 10 days later on the 6th of April that made practitioners sit up and take notice. This was a claim for a mishandled administration valued at £250 million, so large-scale litigation. A 5-week trial of liability and quantum is due to commence on the 8th of June 2020. And an application was made to adjourn that date. It was refused by John Kimball QC, sitting as a judge of the High Court, and he directed that instead the parties were to explore ways of conducting this very large-scale trial remotely. It's important to be clear that the deputy judge didn't direct that the trial would go ahead, but he directed that the matter should be reviewed at another pre-trial review. The outcome of that is not known, but at the very least, this was a clear statement of judicial intent that there should be an element of business as normal. But the best and fullest, and indeed the most recent statement of the principles which are going to inform whether or not hearings can take place remotely is in the Municipio do Mariana case. And if we can move on to the next slide, we can look at what that says. Now, this was even larger scale litigation arising out of the failure of a dam in Brazil. There were a mere 202,000 claimants. The application was, the forthcoming hearing was an application to stay on jurisdictional grounds made by the defendant with a 7-day hearing in June. And again, as a measure of the scale of the litigation, the expert evidence for this jurisdictional challenge ran to reports of 1,300 pages and exhibits of 14,000 pages. The fact that, as we'll see, only a very short adjournment was given indicates that somebody somewhere is not having much fun this lockdown. So the application that was before the court, His Honour Judge Eyre QC, was an application by the defendant to extend time for the service of its evidence in reply. But that application, if acceded to, would result in the adjournment of the hearing. His Honour Judge Eyre alluded to the climate favouring the dealing remotely with hearings, and against that background considered the factors that the court would have regard to in deciding whether or not time limits could be extended. I've listed the guidance that is given on this in the next 2 slides, and you'll see that for the most part the mood music is pretty strictly in favour of requiring legal professionals to pull their finger out. The judge referred first of all to the importance of adhering to deadlines, or where that's not practical, giving the minimum extension necessary, and the court's expectation that legal professionals would make appropriate use of technology. The judge suggested that professionals should rise to the challenge, go further than they would otherwise go in normal circumstances, and expressed a similar expectation of expert witnesses who are obviously acting as professionals, although expressly not litigants themselves. If we move on to the next slide. This was tempered by the consideration the court should be willing to accept evidence and other material which is less polished and focused than would otherwise be required, if that's what's necessary to achieve its timely production. Also to take account of the realities, and while requiring lawyers and other professionals to press forward, to be careful not to require compliance with deadlines which are not achievable even with a proper level of effort, and paid heed in that regard to the consideration that it's going to take longer and require more work to achieve what could in normal times be achieved by more traditional methods. If we can just move on to the next slide. Finally, the court indicated that regard would be had to the consequences of restrictions on movement and the steps by way of working at home which have been taken to address the pandemic, and finally made the point that as is the case in normal circumstances, something will depend on the nature of the extension which is being sought, and in this regard the loss of the trial date will be much harder to achieve than extensions of time in relation to directions which will not have that consequence. So this, as I say, I think is the fullest and clearest exposition of what is being expected, certainly in the High Court. It is right, though, to say that a difference of approach has appeared between the High Court on the one hand and the county courts on the other hand. Certainly anyone who's had dealings with Central London County Court recently will know that hearings are being adjourned wholesale, and there does seem to be a sense in that particular tribunal that this very much is not business as normal. Also, and although Katie and I have consciously decided not to go into detail about the guidance that's been given in relation to the first tier tribunal and the upper tribunal, it's right to say that on the 1st of May, the latest update to guidance for the conduct of proceedings in the upper tribunal at least stated at paragraph 25 that tribunal will be sympathetic to requests for extensions of time, albeit that those will have to be properly explained and supported. So even there, it's not to be taken, I think, as a fait accompli. So that's, I think, those are the main shifts in the litigation landscape. And I'm just going to hand back to Katie now to talk about what we can perhaps expect by way of future legislative and other developments.
Yes, thank you, just really wanted to deal with a few recent government schemes that are attempting to benefit tenants, although it remains to be seen whether they will, and this is specifically commercial tenants. So let me take first the last one on the list, which is commercial rent arrears recovery, known as CRAR. That's the process by which certificated agents, enforcement agents, can take control of a tenant's goods where there are arrears of rent. It used to be the case that only 7 days arrears were required, but on the 24th of April 2020, regulations came into force that increased that rent level to 90 days worth of arrears. So that's quite an important factor for people to be aware of. Interestingly, late last year, there was a case named in the Court of Appeal named BRA, which rhymes with and was about CRAR. And it, in that case, the Court of Appeal held that the exercise of CRAR waives the right to forfeit for the rent that was subject to the CRAR procedure if the landlord elects to take CRAR measures before forfeiture. Given that now there can be no waiver of forfeiture under commercial leases, save by giving express waiver in writing, it seems to me that probably BRA doesn't affect things at the moment. And if the landlord has sufficient arrears of rent, so 90 days, it can elect to use CRAR at the moment, whilst keeping its powder dry on forfeiture at the end of the prescribed period under Section 82 of the Coronavirus Act 2020. So that's CRAR. The first two limitations on the list, statutory demands moratorium and a moratorium on winding up petitions, they are going to be included in the Corporate Insolvency and Governance Bill, although perhaps another unintended consequence of the government announcing these measures before putting them into law may have been that quite a lot of landlords started serving statutory demands early to get a jump on the legislation in the hope they weren't going to be caught by it, and that we'll see if that's happened. But that is yet another restriction on a commercial landlord's ability to take steps against its tenants at the moment. And I really wonder whether that is a particularly good idea in the end, because commercial landlords are also suffering financially. And there is really only so long that a failure to pay rent by a high street tenant can be bankrolled. And the Estates Gazette in a recent article has pointed out that actually of our high streets, a goodly proportion is owned by charities, by local authorities and by pension funds, so not the big corporate landlords who may be in a better position to absorb mass failure to pay rent. Perhaps we need to take that into account when looking at the restrictions that are imposed on rent recovery at the moment. And I really wonder whether the short-term restrictions are going to actually lead to long-term pain for tenants when they open back up again and they find themselves faced with a landlord who's really got no option but to take steps to recover the arrears. And it seems to me that probably tenants should at the moment be speaking with their landlords and engaging in open dialogue and trying to come to some sort of arrangement rather than walking away from negotiations because of the protections that the government is giving them, because they're not going to last very long. There's been some suggestion in recent days, and we don't know what form it's going to take, but in recent days there's been some suggestion that there may be a furloughing of shops, which potentially will mean that the government may take on, through the taxpayer, a proportion of rent owed to landlords in respect of commercial shop premises. that's something to keep an eye on. It's under consultation at the moment. It may happen, although given what we've been hearing this morning about the proper furlough scheme for employees being limited and wound down, maybe that's not going to be a runner, but we'll just have to see. It's something to keep an eye on. Another interesting issue that has been keeping me awake at night is how people are actually affecting service of statutory demands at the moment, given that there may shortly be a moratorium on them. How is personal service of a statutory demand on an individual debtor to be affected if that is going to breach social distancing guidelines? If anyone is doing that and has got some knowledge to share, I'd be grateful to hear, because it's quite an interesting practical point that I don't know that anyone's raised yet. So we'll see really how these new restrictions play out in a post-COVID world, but those are the current plans that the government has. And that's really all I wanted to say about these further measures. Andrew's now going to give some closing remarks and wind things up. Thank you for listening.
Thank you very much, Katie, and thank you all for tuning in to this inaugural talk. Colleagues of ours will be giving future talks, I think in the same weekly slot, so please look out for those and sign up. We're obviously living in a very uncertain world, and a world that looks set to remain uncertain for a very long period of time. It's suggested so far as the way in which we're conducting litigation is concerned, that there are certain things that are here to stay, particularly the prospect of remote hearings, I think, no longer holds the fear that it might have done a couple of months ago for most practitioners. And similarly, very good reports are coming back about the workings of remote mediations and an end to late nights in bleak offices drafting settlement agreements. So I hope that everybody is enduring a tolerable lockdown, that there's enough work around to keep everybody busy, and most importantly that people are staying well and healthy, and that we'll all be back to something approaching normality soon enough. In the meantime, thank you all very much for listening, and as I say, please do tune into our colleagues' talks in coming weeks.